Hi everyone, we are delighted and excited to have you here and be a part of your journey to exam success. I am Ngozi Emmanuel and I oversee all administrative aspects of the NCA guides. Before we dive into the review proper, permit me to give a broad overview of who we are and what we do. The NCA Guides is a registered partnership of 5 seasoned and experienced tutors who we also refer to as guides. We employ a guide approach because we believe that every candidate has what it takes to successfully challenge the NCA examinations, and our part is to guide the candidate to success. We understand the difficulty that the NCA examinations present, and we help candidates overcome the obstacles and difficulties in understanding the course materials and examination formats. We do this through intensive classes, revisions, and examination review workshops. We do not believe in a one-size-fits-all approach, and our study sessions are focused on helping candidates understand the course material in a way unique and personal to them. In addition, we also offer private and intensive tutoring sessions for candidates who are in need of a direct one-on-one session. If you are interested in registering for our private tutoring session, please reach out to us via email at inquiries@ncaguides.com. Once again, I would like to say thank you on behalf of the NCA Guides team for joining us today.
So yes, my name is Hidayat. My friends call me Heidi, so you can go ahead, call me Heidi. I'll be your guide for today. We are here to talk about criminal law. We are here to introduce the course to us to ensure that we have easy time studying and to enable us better assimilate the course. So we are here to just give you some tips on how to go about your studying. Before we delve into the class, one thing I like to always sort out is the course materials that you'll be using, right? The criminal law exams will start January, and I think registration is open November 17th, I guess, and would actually be closing December 6th. So if you've not registered for the course, I would say go ahead and register right now before it closes. You have up until December 6th to do that, right? I also want to let you know that the call is being recorded, and it's great for you because it means that even after the end of today's session, you can have access to the videos. We'll post it on our YouTube page. So as per the course materials, NCA require that you have your syllabus. I want to believe we have a syllabus with us. If we don't, I would say please go download your syllabus on the NCA website. The syllabus is like your roadmap to success. So I don't think anybody should underplay downloading the syllabus. As a matter of fact, we will be using the syllabus into this class. So please go ahead and download your syllabus. The syllabus was recently reviewed. I'm sure we all know that. You have a couple of cases that had been, added to the syllabus. I would want us to get more acquainted with those cases, right? So yeah, please go ahead and download your syllabus. Another thing you need is your criminal code. You need your criminal code, and your criminal code, the ones the NCA suggests you have is the annotated one. So you are able to have some commentaries alongside the what's it called now? The sections you'll be reviewing. So the criminal code is annotated one is highly recommended because it actually guides you more than the pocket criminal code would do, right? So I have the Alan Gold. There are a couple of great ones out there. There is the Martins as well. So I'm going to show you my criminal code so you can have an idea of what it looks like. So it's a bit wrapped up, but yeah, I don't know if you can see, it's Alan Gold. You can order it on LexisNexis. That's for the criminal code. So I've mentioned your syllabus, I've mentioned your criminal code. What about the textbooks? So the NCA also recommends 2 basic textbooks for you. That's the Cullen and then the Kentridge. the stiff colon is the criminal procedure. It talks about the criminal procedure, while the controls talk about the criminal law. So the two textbooks are there for you as well. But recognizing the students, or most of us would rather not read the textbooks, would want something more concise to enable us read as fast as possible. I don't know what's, just give me a sec, yeah. Yeah, so aside from the notes, you have the textbooks, rather, you have the notes that have been sort of summarized in a way that aid your reading as well. So if you do not want to use the textbooks, what I'm saying basically is that you have the criminal law notes that you can purchase on the NCA, on our website, www.ncagaguides.com. Manuel Akishola's note. So you could go on there and then, give me a sec, I'm being distracted with, sorry guys. Let me see what's, I'm sure you guys can see what I can see on my screen. That shouldn't. Yeah, sorry, my administrator is just trying to help me pull up some of the things I'm talking about. So the Manuel Akishola's note is on the website for you. You can purchase that. It's a summary of the criminal law textbook and the criminal procedure textbook. So it's great for you as well. And another thing you have that you should have is aside from the notes, which is great because you have your textbooks, you have the notes that summarize the textbook. Writing the exam, or you need something more concise than the notes as well. So here you have the answer framework that the NCA are trying to put up together for you, NCA guides that are trying to put up together for you. That will be useful in the examination hall, and that will also be available for you to purchase on the website. So as far as your materials go, those are what you need. So I've mentioned the syllabus, you can't leave that out. I've mentioned the textbooks, I've mentioned the notes, and I've mentioned the answer framework that can guide you in your exam as well, right? So that is as far as your materials go. So now I'm going to stop for a bit. I want to hear if you've got your syllabus. I want to hear if you've got your textbook. If you don't have your textbook, I want to know if you have your note. I just want somebody to tell me on this call that as far as my materials are concerned, I'm good to go. So I'm going to ask Tope Lucas. Can you hear me? Hi, how are you? You can please unmute your mic and speak to us about your course materials. Do you have your syllabus?
Yes, I have my syllabus, but I don't think I have my notes just yet.
Okay, at least you have the syllabus. That's a good way to start. Are you going to be using the textbooks, or you would use the notes, or both?
I'm going to be using the notes.
Okay, good.
Criminal code, yes, I have the annotated criminal code.
That's very good. So Tope Lucas is good to go. I'll hear one more person before we start today's class. I'm not able to see my screen very well. I don't know what my administrator is doing with my screen. It's just making me look like. I see Cherry, Chichi. Do you want to come in and say something? Do you have your syllabus?
Yeah, I have that.
Okay. What material are you using? Are you going to use your textbook, or are you going to use your notes?
I'll be using the notes, but I don't have it yet.
Okay, sounds good. Okay, so that's great. We have, I want to believe we all have our syllabus. We'll be using the syllabus to run through today. Tope Lucas, do you want to say something? All right. So here we go. So criminal law. We are here to have a bit of introduction as to criminal law, and we want some sort of guide as to how to study. So what exactly is criminal law? You know, your criminal law is just a body of law that sort of relates to crime. As simple as that. It essentially prohibits some conducts, you know, that is threatening or harmful to the society. It's sort of have some sort of some laws that regulate the conduct in the society. That's essentially what your criminal law is about. So as far as NCA is concerned, what is expected of you as the NCA candidate? What do you need to put down in your booklet for you to pass your exams? NCA requires that first you should have the ability to identify relevant issues. If you're a first timer for the NCA exams are theory based, like you have a bit of scenario painted to you, real life issues, and NCA expects that you are able to deduce relevant issues and then answer your questions based on the relevant issues that you have identified. So your ability to identify relevant issues will help you in succeeding in your exams, right? So that is one. We are going to achieve that in our intensive classes. And your ability to also understand applicable laws, applicable principles, and elements of your offense. That is also very basic. You need to be able to understand the principles of law that relate to the issues that you have identified. I don't know if that makes sense to you. So first you identify your issues and then you know the laws or the principles that apply to them. That's very essential. We'll get to that as well. Another thing you should understand as far as criminal law is concerned specifically is that you need to understand, you need to have the ability to identify the burden of proof. When you talk about criminal law is all about establishing that a crime has been committed or disproving that the crime has been committed. So on whom would the burden of proof lies? You need to have the ability to identify that as well, right? So my screen is just going berserk on me. My administrator, please, can we have focus? Thank you. So yeah, so you need to have the ability to identify the elements of your criminal law offenses, and you need to be able to identify the burden of proof. We'll get to that as well. So first, I mentioned you understand your ability to identify relevant issues. You need to have the ability to understand the basic principles of law and the elements of criminal offense. That's 2. 3, you need to have the understanding of burden of proof, on whom it lies and how it shifts. That's 3. And then the 4th one, you need to be able to relate these identified rules to the issues that you have identified. That's 4. 5, you need to be able to conclude logically, right? So if you have all of these pointers before you, you're able to understand exactly what you intend to achieve in your study and how it helps you to translate to success in your exams, right? So now that we have that out of the way, we're going to run through the syllabus. Perhaps we may not be able to get down to everything, but hopefully we can achieve some great detail, achieve something while we go through it, right? So now we're going to use the new syllabus that we have. Your syllabus contains 32 chapters. In the 32 chapters, I have been able to dissect the syllabus in such a way that I break it down into 5 segments. So for your criminal law, in your exams, you are certain to get questions on offenses. You're certain to get questions on defenses. You're certain to get questions on police powers. These are all topics in your syllabus. The 2 other parts, sometimes, which is the procedure and the sentencing part, sometimes you get questions on them, sometimes you don't. But you see these 3 parts I've mentioned: offenses, defenses, police powers. I've not seen any NCA exams where you don't get questions on them. So you're gonna have to pay a whole lot of attention to these 3 parts of your syllabus. Like I mentioned, you have 32 chapters in your syllabus, right? In our intensive classes, we would deal with these 32 chapters under 5 headings that I've just mentioned: offenses, defenses, police powers, procedures, sentencing. Appeal is part of your syllabus, which is the last topic, but I've not seen any NCA questions on them. It doesn't mean we won't pay attention to it, but it's just for us to be able to focus more on what we know is sure to come, right? So for your offenses, the NCA syllabus itself, because your criminal code is big, you have several offense sections in them. It's almost impossible. It is impossible to touch on all the sections in your criminal code. But what the NCA expects you to know is the elements of the criminal law offense. When you're given any section in your exam, in your examination, you should be able to dissect this section, analyze it. Either you're speaking for the prosecutor or you're speaking for the defense. You need to have the ability to analyze that section in such a way that you highlight the Actus Reus and the mens rea required for that offense. That ability that you need to be so analytical when it comes to elements of your criminal law offense is what we will be focusing on when we discuss the offense part of the syllabus. I don't know if this makes sense to us, right? It is impossible to touch on all the sections in your syllabus. What NCA expects you to know or do is to understand the elements of your criminal law offense. With that knowledge, no matter the section you've been asked to review in your exam, you will be able to review it because you know the fundamentals, what is required. I don't know if this makes sense to us, right? What I've said so far, does it make sense?
Yep.
Yeah? Okay, so now, understanding the elements of the criminal law offense, we'll try to look into that into this class, but I want to be able to run through the syllabus as it appears. So your first topic in your syllabus is the sources of criminal law, right? And for a bit, I want us to be able to, I know we are always under the examination pressure, but for me, what I've seen with criminal law is if you understand the rudiments of it, if you understand the jurisprudence or the fundamentals of criminal law, you're going to be able to place every other thing on that knowledge, that fundamental knowledge you have, and it becomes easier to understand, right? So the entire concept of criminal law is saying that some offenses, some conduct have been prohibited. Do not do X, Y, Z. If you do X, Y, Z, this is the penalty for it, right? That is the power that the government have to legislate and give prohibit some conducts, right? So, but in the process of taking away or trying to punish somebody for crime, it is expected that you also, recognize their rights, their charter rights. So if I'm going to get punished for a crime, you are going to take away my right to liberty by sending me to jail, you should be able to follow or do so in accordance to the law. So this is the basis why we talk about all the things we talk about in criminal law. This is the basis for it. Whatever you do in taking away my liberty must be done in accordance to principles of fundamental justice. So in understanding your criminal law, I mentioned earlier that you understand the basic principles, and then part of the basic principles is understanding the law and presumptions, right? And there is no how you talk about the law and presumptions that you are not going to touch on the charter. And I'll give you an example. So for example, you have the presumption of innocence. We all know about the presumption of innocence, right? Everyone is presumed to be innocent. What does this mean? It means that if you're going to charge me to court for a certain offense that I've committed, the law already presumed me innocent. What does this tell you? It tells you that the job or the obligation to prove that I've committed the offense rests solely on the prosecutor. So the burden of proof is on the prosecutor simply because the law presumes me innocent, right? So when the prosecutor goes to court and introduces all the evidence that he or she has to say that Idayat has committed XYZ offense, then the burden shifts to the defendant. It shifts to the defendant to come say, okay, now I need to say that every evidence that the prosecutor had introduced in courts should not be admissible or should not be accepted because of XYZ. The defense is then coming in that light. So your presumption of innocence helps you to understand the burden of proof, and then it also helps you to understand how it shifts, right? Then if you talk about another presumption you have is the presumption of sanity. Everyone is presumed to be sane. So if you go to court and you say, okay, I committed XYZ offense because I was suffering from mental disorder, that burden is on you. That burden is on the defendant to say, okay, because of the presumption of sanity, then the burden to prove that you are insane rests on the defendant. I don't know if this makes sense. So if you understand your law on presumptions, it helps you to be able to tell who goes first in court, right? So if you say I'm insane, then you have to prove to the court that you're actually insane. So the burden is on you. So if you understand some of these presumptions, it helps you to have a clearer picture of exactly what we are expected to know in the criminal law syllabus, right? So that's just one of the things I need to get out of the way. Now, the sources of criminal law. What are the sources of criminal law? Basically, your sources of criminal law is the code. And the code is enacted by the parliament, by the federal parliament. So the sources of your criminal, one of the sources of a criminal law is the criminal code. It doesn't mean that you don't have any other, acts or legislations that prohibits certain conduct, but most of it have been subsumed under your criminal code. Sometimes you have other laws that may be given to you, but for NCA purpose, the focus really should be on the criminal code. So one of the sources of your criminal law is your criminal code, and it helps to all of the offenses that you'll be treating largely in NCA would come from that criminal code, right? So you have other enactments like your Narcotics Act, for example. So you have instances where the government would say they want to curb a specific crime. They may decide to have separate enactment for those ones. When you do have such, and you have been faced with a question from one of those legislations, NCA will provide you with that in your exams, right? So you would not have to worry as to where do you need to get, or we've analyzed the sections that you've been given. So it's either you have your criminal code or whatever other legislation will be provided to you. But in my experience, all you have to do is to focus on your criminal code, right? So yeah, your sources is one of that is the criminal code. And the major reason why you have your criminal code as a source of criminal law is that you need for any act that would, any conduct that will be prohibited, you need it to be certain, you need it to be written. Because, for example, you cannot be convicted for a crime that had not been legislated on. You cannot be convicted for a crime that is not in existence, or that it is not clear, it's not in written terms. So you have that criminal code as a guide. So if you've been charged for an offense that had not been codified, for example, that is a basis for a defense to say nobody can charge you for a non-existent crime. So it is for that basis that you have your criminal code codified. Because you need to be able to ascertain or achieve some certainty, right? So because that your criminal code is codified helps you to achieve clarity in how you prosecute the crime, right? So you have your common law is not a source of criminal law because of the reasons we've just mentioned. Common law is unwritten. You are not able to prosecute somebody on an unwritten law. So it is for that reason that your common law is not going to be a source of your criminal law, right? But as much as your common law is not a source of your criminal law, it is a source of your defense. You have several defenses that is common law based. You will come across that as we go ahead in the course. For example, your officially induced error is a common law defense. Your entrapment is a common law defense. We'll talk about that when we get to defense. And your common law is also very useful in terms of interpretation. So even though it is not a source of law, so to speak, it helps because in interpreting common law, the principles of law in criminal law. For example, one of the cases you've been given in your syllabus is the case of R and Jobidon. In R and Jobidon, for example, it's a case that talks about consent, right? When we move forward in the class, we'll get to talk about some offenses, one of which will be assault. This case is very relevant when you talk about assault, because for you to be able to establish a crime of assault, we need to talk about the Actus Reus and the mens rea. And one of the Actus Reus of that is you need to be able to show that the person you assaulted did not consent to the assault. If the person you assaulted consented to the assault, then you will not be having Actus Reus, right? So you would need to show that as part of the element of the offense of assault, that the person you assaulted did not consent. That's one of the job of the prosecutor, right? So in your R and Jobidon, it's a common law principle that the court established in that case is that no matter how much you consent to assault, nobody can actually consent to a grievous assault. Nobody can consent to a very, high-level assault that sort of endangers them, so to speak. You understand what I mean? So if you say Idayat consented to slapping, Idayat consented to the assault of, maybe you slapped me, and you slapped me to the extent that you left me with some injury, and then you go to court to say Idayat consented, and the court will tell you no, that she's not going to consent to that sort of assault. Nobody is going to consent to a grievous assault. I don't know if this makes sense. So what makes the court, the ability for the court to say that what gives the court the power to do that is the common law principle that was established in the case of R and Jobidon, right? So you have your source of criminal law as your criminal code, basically, and other laws that have been enacted. The jurisprudence is that your common law can never be a source of a criminal law offense. But even though it is not a source of a criminal law offense, you would know that it is still very relevant in the sense that it helps in establishing some defenses. And then it is also very relevant when you're trying to interpret some principles of criminal law, just like we just highlighted in the case of R and Jobidon. I don't know if that makes sense to us, right? So for NCA purpose, when you deal with this in your exam, because when you look at your topics, you look at it as if it's just abstract, but how do you apply it when it comes to your exams, right? The last exam that they wrote, that's the October exam, excuse me. Part of the question they gave was the NCA gave another legislation in that exam for them to review. And according to the story, the defense counsel in that scenario was saying that there was no offense, that there is no, because the offense was not in the criminal code, it is not an offense. It's a defense they were going to come up with. So when NCA asks you questions like that, it's pointing you to chapter 1 of your syllabus, because your chapter 1 had explained to you your sources of your criminal law. So the fact that a particular offense section is not in your criminal code is not enough to say it is not an offense. Now, if you do not understand the reason why this topic, sources of criminal law, is in your syllabus, you are likely not to avert your mind to that, because exactly what NCA expects you to say in that scenario is that, yes, your criminal code is your source, is the major source of criminal law in Canada, but there are other enactments that have been enacted to accommodate some other specific offenses. So if you get to court, for example, and somebody is saying, oh no, the section that you've been charged with is not in the criminal code, and as such, it is not an offense, then your chapter 1 of your syllabus becomes very relevant to you, because it is that part you're using to say, oh no, yes, I've been told that even though it is not in the criminal code, it's as far as it is an act of parliament, and it has been established to prescribe or prohibit a particular conduct, then it is a source of criminal law in Canada. That is the whole essence of why your chapter 1 is there. And then, of course, the common law, the relevance of the common law. It is a source of your defense, and it is a source of interpretation of your criminal law principles. That's the whole essence of your chapter 1. Most of the NCAA exams I've seen, they don't touch on chapter 1. The very first one I heard of was the exam they wrote in October, and I told my students, yes, this is what NCAA expected you to say to them, right? So that is for your 1. One thing again, chapter 1 also touched on is, sometimes you find that some conduct are so bad that you expect it to be a crime. So somebody is doing something that you feel morally is wrong, and you expect that should be an offense. It is not necessarily so. So what is actually an offense is what the parliament has codified as an offense. That you feel something is so awful to be an offense does not mean it will be an offense, right? And that is where the case of your Frey and Federal comes into play. So that's most likely, that's one thing. So basically, this is what we expect you to understand when it comes to your sources of criminal law for your chapter 1. So I think it's safe to go to chapter 2 now. Do we have any observation about my chapter 1? Chapter 1 is not so critical, like you can gloss through it like I just did, and that's essentially what it is. But it's important that you understand it as well. Do you have any observations so far on chapter 1? Paula, do you want to say something about your sources of criminal law? What do you see so far, what I've said? You can go ahead and unmute your mic. You are not able to unmute? Wow, and I can't do that for you as well. Who else can unmute themselves and talk? Please try to see if you can unmute yourself. Chichi, yeah.
Yeah, I think it was quite clear what you explained.
Yeah.
Yeah,
okay.
Sources, I understand that contempt of court is a common law offense, and apart from the criminal code, there are other legislation, statutory federal legislations that also enact criminal offenses.
Good.
So in the context that you mentioned about the exam, maybe one can also postulate that even if it's not within the criminal code, if it has been enacted in another federal legislation, it could also be a valid criminal offense.
Very good. That's the point. Yeah, Chichi, I'm happy you're following. Who else want to say something? I want to hear you on chapter 1 before we move to chapter 2. Is it clear? Cherry, so far?
Okay, sorry, I've been able to unmute.
Thank God.
Okay.
Okay, so what's your perception so far?
Like what you told us, it's not just the criminal code that is one of the sources of criminal law. We have common law. Common law is not really a source except for some defenses.
Good.
Yeah. And then you talked about some other statutes that are also sources. And then you also talked about the presumptions that we must know. The presumption of innocence. You are presumed guilty until you are proven.
You are presumed innocent.
You're proven guilty.
Yeah.
And then the presumption of sanity. And you said that the burden of proof lies on the defense. I mean, the person that is saying is insane or is innocent.
Good. So I'm happy you're also following Paula. Yeah. When we go into the intensive classes, we'll go into more details on these things. But essentially, that is good. You are good to go on that.
Thank you.
Yeah. So that's chapter 1, and I'm glad you all followed that. So now let's go to chapter 2. So the power to create criminal offenses and rules of criminal procedure. So who has the power to create criminal offenses in Canada? It is very important that we know that it is the federal government, i.e. the parliament, that has the power to create criminal law offenses. It is only the parliament that has the power to create criminal law offenses, right? And that you find in your section 91, subsection 27 of your Constitutional Act of 1867. So even though it is just the federal government that has the power to create criminal law offenses, there are other types of offenses that we'll come to learn more in class called the regulatory offenses. These regulatory offenses are offenses that just, see to the welfare of the society. The aim of regulatory offenses is not actually to penalize the accused person. It is to ensure some sanity when it comes to affairs of the state. For example, when you talk about waste management, talk about traffic offenses. These are examples of regulatory offenses. So regulatory offenses fall within the purview of the provincial government as much as it falls in the purview of the federal government. So the federal government alone has the power to enact criminal law offenses. However, both the federal government and the provincial government have the power to enact regulatory offenses. Does this make sense? And for the provincial government power, you find that in your section 92 sub 14 of the Constitutional Act of 1987, right? So that is essentially where you get your sources of criminal law and regulatory offenses from. So now, I always tell my students this: when you go into your exam hall, you are definitely going to be reviewing offenses. What offense you'll be reviewing, we don't know. It may come from the criminal code, it may come from another law, from another legislation. So when you ask to review a particular offense, the first thing you want to see is where is the source of this offense. If it is the criminal code, you are most likely dealing with a criminal law offense. If you find that the offense you've been asked to review is in a provincial statute, for example, then it cannot be a criminal law offense. It has to be a regulatory offense. Does this make sense? Right? I want some response, like,
yep.
Yeah. So basically that is it. So when you look at your criminal law offense, you're asking yourself, what constitutes criminal law offense? How do I differentiate your criminal law offense from the regulatory offenses? The first thing to note is that your criminal law offenses will be in your criminal code, and you would have to give the case of your Aramamo Levine. It is the case of Aramamo Levine that defines criminal law, right? What are the things to look out for when you talk about criminal law? You're going to talk about, I call them the 3 Ps, right? It has to be prohibited, that's first. It has to have some penalty, and it has to have some public purpose. So your criminal law must be able to serve these 3 functions. And that is one way to distinguish it from your regulatory offense. Your regulatory offense, the aim is not to punish you, like I said. It is just to ensure that people abide by certain conduct in society, right? So one way to distinguish it also is the moment you have an enactment in your exams, and it is a provincial law enactment, then you know that you are most likely dealing with a regulatory offense. The federal government, that is the parliament, also have the power to enact regulatory offense. And sometimes you have these regulatory offenses also in the criminal code. How you are able to differentiate it is one of the things we'll be talking about in the intensive classes, right? But good to say that when you go ahead to study for your exams, bear in mind that you have 2 types of offenses. You have your criminal law offenses, and then you have your regulatory offenses, right? Your regulatory offenses, like I said, are social welfare offenses, most often enacted by the provincial government. Your criminal law offenses enacted by the federal government, always in the criminal code or some other enactment, act of parliament, right? So that's basically your source of the power to create the criminal law, criminal offenses, and then the rules of criminal code. So yeah, so you have that that under your chapter 2, and then you have the Canadian Charter of Rights and Freedom that also helps to, it sort of helps to regulate the conduct of the government, right? So are you raising your hand, Dr. Lucas?
Yes.
Please go ahead.
For the offense, you only have criminal offenses and regulatory offenses.
Yeah.
Okay.
Yeah. So you have some other, you have the Canadian Charter of Rights and Freedom, which I always call the watchdog, because it's the law that sort of ensure that the governments, comply with or pay attention to the rights and privileges of Canadians. So if you have to prosecute me, because of course the power to prosecute now rests with the government, right? So if you have to prosecute me, the way and manner you go about it must be in accordance with the principles that have been, enunciated in your Canadian Charter of Rights and Freedom. So if you're gonna send me to jail, for example, you have to do that having in mind the fundamental principles of justice, right? What are the 2 pillars of justice that we know? Now, you talk about your audi autorem patem and your nemo judice in casusua. I'm sure we all know these principles. We call them the twin pillars, right? So your nemo judice is saying that all parties must be heard. So if you have to charge me to court, then you must give me a fair hearing, right? So this is where your Canadian Charter of Rights and Freedom come into play. If you have to charge me to court, then you must give me, I must be, tried by an impartial tribunal. This is where your charter also come into play. How that actually into play, we'll be looking at it in critical or in more details when we come into the intensive class, right? So you have that, there are a couple of cases in there as well. For example, you have your Canada and Bedford. You have, that is the case of the prostitute case. I don't want to go into analyzing cases today because we might waste a whole lot of time on that. So, but you have these cases in your syllabus to point to you that any law that has been enacted by the federal government must be in compliance with the charter, otherwise it stands the risk of being struck down. And your Canada and Bedford is one of the examples where the sections of the criminal code was struck down because it was not in compliance with the charter, right? So your charter, your Canadian Charter of Rights and Freedom is there to sort of ensure that the government does not downplay the rights of the citizens, so to speak. Your Aaron Oaks is also there in your syllabus. I'm not going to review that in details, but the Aaron Oaks is a case of the guy who was, he talks about the presumption, possession of marijuana. So previously, the presumption is that once you're caught with marijuana, then the purpose is for trafficking. The presumption was said to be contrary to the charter because it shifts the burden of proof from the prosecutor to the defense. So if I am caught with marijuana, I should not be presumed that I'm in possession of it because I want to traffic it. It is for the prosecutor to prove that I am in possession because I want to traffic it, not for the law to presume it to be for the purpose of trafficking. Also is a case we look through very well in the intensive class as well. There are a couple of other cases in here. You have your Aaron Labaye, for example. Aaron Labaye is also a case where the guy in this case sort of run a prostitute house, and he has some regulation around it where he wouldn't admit anybody into the prostitution house unless you're a member, right? And he was charged for running the prostitution house, and they call it a bawdy house. It's against the law in the criminal code, and the court had to analyze or review whether it was actually whether it was a criminal conduct, whether the act that it was doing was actually indecent. So the issue was whether running that house was an indecent act. So the court reviewed that, like, vis-a-vis his right to, go about his business. We'll look at that also in the intensive classes. So we'll go through to the third topic, which is the procedural classification of offenses. How do you classify your criminal law offenses? Your criminal law offenses are divided into two. We should know that as well. right now. You have the indictable offenses and the summary offenses. And this is very important when you talk about, excuse me. This is very important when you talk about how to go about prosecuting these offenses. It's important for the penalty that will be imposed, and it is also important for the procedure that will be adopted. So because you have two types of, well, not really two, you have the one that can be called hybrid, right? So you have your indictable offenses, you have the summary conviction offenses, and then you have one they call hybrid offenses. It is hybrid because it essentially means that the prosecutor will have the discretion to choose how he or she prosecute the crime, whether he would want to prosecute it by way of indictment or by way of summary conviction. So when you think about classification of your offenses, it is very important that you have at the back of your mind that the way and manner the offense is prosecuted and the penalty that may arise as a result of that prosecution is very important, right? So you have your indictable offenses that usually you call them the more serious offenses. The more serious offenses. So you have your offenses like murder, you have to prosecute it by way of indictment. And then the summary conviction offenses are seen to be the less serious offenses. But there are a couple of exceptions around this area, such that it is so dicey and confusing now that there is the suggestion that the criminal code has to, or the government has to do better in separating what amounts to indictable offenses or what amounts to summary offenses. But for the purpose of NCA, it is you're good to go when you view it in terms of the gravity of the offense. So your indictable offenses are the serious offenses, your summary convictions offenses are the less serious offenses, right? So this separation is important because it has two implications. So if you proceed by way of indictment, what procedure are you going to be adopting? In Canada, you know, for example, that you have the jury trials, right? So you would not have a jury trial when you're prosecuting by way of summary conviction. You will have a jury trial when you're prosecuting by way of indictment. Like I said, there are exceptions to it because you have some offenses that are indictable that you would have the jury trial, but the exception, you could have a situation where the accused person says, I do not want to be tried by a jury. What happens in that instance? That's where you have some of the exceptions, right? So, but for us to understand clearly the whole essence of separating this offense, it has impact on penalty and it has impact on procedure. And when you go into your exam, so this is better left for the exam review, but the way you see it is when you've been given an offense section to review, ask yourself, is this an indictable offense? If it is an indictable offense, you know that you are most likely going to be talking about the jury. You're going to now have to bring in all the knowledge you have about jury trials in Canada. You will get into that as well. There are a couple of principles around that. So when you have an indictable offense, you know, one, you're dealing with jury trial, mostly. There are exceptions, have that at the back of your mind. And then you're going to have to go by way of indictment. You actually file an indictment when you're talking about indictable offenses. But when you're dealing with your summary conviction offenses, remember, those are the less serious offenses. You're not going to have a jury trial. So it deals with jurisdiction as well. In Canada, most of the summary conviction offenses are tried by the criminal court jurisdiction, i.e. the provincial courts, right? The indictable offenses, some of them are tried by the provincial court, but most of them are tried by the superior courts. The courts you call your Section 96 courts in your constitution, right? So it is important you know the type of offense you've been asked to review so that you begin to think about three things, basically. Jurisdiction, which court is it going to go to? Procedure, how am I going to file the case? Am I filing an indictment or am I filing an information? If it is a summary conviction, you are filing an information in court. If it's an indictable offense, you are filing an indictment in court. So when you think about the type of offense you have, like I said, three things are coming to your mind immediately. The jurisdiction, what court is it, right? The procedure, how am I going about the charge? The penalty, what are the penalties that this accused may have, right? So when you talk about the first one, I already mentioned that you're dealing with the court. Your summary conviction cases go straight to your provincial court, which is like the lowest cadre of court you have. And then your indictable offenses would go to your superior court, which is like in Alberta, you call them the Court of Queen's Bench. So it's the step, ahead of the provincial court, right? So when you have your indictment in the province, you have some offenses that would go to the Court of Queen's Bench, and then you have some that goes to the provincial court. Most of the summary, all of the summary conviction offenses would go to the provincial court, right? So for your procedure, for the purpose of NCA would not dwell much on procedure because realistically, there is no way they can test you on that. But NCA would delve more on penalty and we delve a lot more on jurisdiction. Just to mention one line, this case will be tried in the provincial court. When it comes to your penalty, right, if you're dealing with a summary conviction offenses, you know for certain that the penalty cannot go above 2 years imprisonment. If you're dealing with a summary conviction offense, what I said was that your penalty, that's the punishment, cannot go above 2 years, right? And this is very important when you're also dealing with sentencing. I will come to that as well. So now for your summary conviction offenses, the penalty cannot be above 2 years. And what that means is that the accused person would have to serve the term in a provincial prison. In a provincial prison, right? So I've said for penalty, it cannot be more than 2 years, and the term of imprisonment will be served in the provincial penitentiary. That's provincial prison, right? And then for your indictment, for your indictable offenses, the punishment is above 2 years imprisonment. And for those indictable offenses, you'll find them in your criminal code. When we go into the criminal code, sometimes you find the parliament says anybody who contravenes this law will be charged with an indictment. Anybody who does XYZ is an indictable offense, or anybody who did as done XYZ will be subjected to a summary trial. Sometimes you will find it in the body of the offenses, right? But sometimes you don't. So how you know majorly is that you find it in the body of the offense. And when you don't, it means that the law is leaving the prosecutor with the discretionary power to choose how to try that offense. Does this make sense to us? When the prosecutor has the discretion to choose how to try the offense, a couple of factors come to play, right? As a prosecutor, imagine yourself as a prosecutor. There is an offense that had been committed, which the parliament has left you with the discretion to decide how to charge. You know now with what I've said that if you go by way of indictment, you are basically telling the accused person is going to spend more time in jail because the punishment is 2 years and above. Does this make sense? If you go by way of summary conviction, if you are being magnanimous and you say, oh, I'm just going to file an information, it means that you've elected that that accused person will serve less than 2 years imprisonment. Does this make sense? So some of the factors that help the prosecutor to decide whether to go by indictment or whether to go by summary conviction is the antecedent of the accused person. If you have an accused person who is an habitual offender, who had committed several offenses in the past with records of convictions, the prosecutor will say, oh, this person looks like a threat to the society. I think he needs to learn more about how to live well in the society. Therefore, go to jail for more than 2 years. Then as a prosecutor, you exercise your power and then you file that indictment. But when you look at the accused person that is before you, and you see that he's a first-time offender, he's young, and the kind of offense that is committed is not so much, it's not so much a deal, does not have so much gravity. In your mind, you say, okay, because he's a first-time offender, I can just file a summary conviction. So I can just file an information. That way, what you have done is that this person is not going to go to jail for more than 3 years, right? So when you leave it that way, you give the prosecutor the discretion to choose. And one of the factors the prosecutor will have to consider are some of the things I've just mentioned. But if it is by way of indictment, it means that you're now going to have to talk about the jury trial. Because in Canada, there are 3 types of trial you could have. You could have the trial with the jury and the judge. You could have one with the judge alone, right? And the third one, which one would it be? I can't recall the third one right now. So you could have the jury trial. And when you're talking about the jury trial, there is this chapter of your syllabus that now come to play. It talks about the jury trials and what the qualification of the jury, how you select the jury, all of that will now come to play, right? So, but for the purpose of your exams, you just need to know that when it comes to an indictment, first mostly would go to the Superior Court, which is in Alberta, the Court of Queen's Bench, 1. 2, then you have the jury trial. Now, there are instances where the accused person, most times when you want to charge an accused person, you give them the right to choose how they want to be tried. So you say, how would you want to be tried? The accused could say, I want to be tried by a judge alone. When you are being tried by the judge alone, the judge is the arbiter for the fact and the law. The judge is reviewing the facts, is reviewing the law. When you're being tried by a jury, the jury takes the fact part away from the judge. So the jury will focus on the facts of the incident as it happened. It is the jury that will be given the conviction. Let me ask you, what is the difference between a conviction and a sentence? Any taker? Conviction, sentence. I'm about to say something, but I want to hear you. You know, I said it's supposed to be an interactive class, right? So let's quickly have that chat. What do you think is the difference between a conviction and a sentence? Anybody? Please go ahead, Chichi. Okay. KA, I can't see. Please go ahead.
My name is Kemi. Okay, well, what I think a conviction is a person has been decided or assessed to have committed an offense. So all the facts have been analyzed and the judge or the jury or both of them have agreed that he has committed the offense. But a sentencing is when we say, okay, for this offense, this is the punishment that will be meted out to you. So they're 2 separate things. Sometimes you can be convicted of an offense, but your defenses will avail you. But if there are no defenses that will avail you, then you face the full sentence or whatnot.
Okay, Kemi. Yeah, you're on the right track. Essentially, that is it, right? So for your conviction, the jury, having reviewed the fact, is pronouncing the verdict. So it's saying this accused has been pronounced guilty, or this accused has been pronounced not guilty. That's your conviction. So now in a jury trial, that is the job of the jury. The other side of which is the sentence, it is the judge in a jury trial or in all trials that will pronounce the sentence, which is a matter of law. So your conviction is a matter of fact, and then your sentencing is a matter of law. So it is the judge that is saying, based on the conviction and based on the sections that you've been tried, this is the sentence that is due to you. So you go to prison for XYZ years or whatever sentence the judge has deemed fit to pronounce. So that's majorly the difference. So when you're dealing with a jury trial, the jury will take away that job of analyzing the facts and reaching a verdict away from the judge. So the jury is the will be in charge of the facts section of the trial, while the judge will be in charge of the law section of the trial, right? So when you're charging your accused person, you give them the right. They have the right to actually choose the mode of their trial. So when your accused person says, I wish to be tried by a jury, and it is an indictment, then he gets a jury trial. Sometimes the accused would say, oh, I don't even wish to be tried by a jury. I wish to be tried by a judge alone. Then he gets a judge alone trial. So, but there are some offenses where the accused person will not be given that choice to choose. When you're dealing with cases of treason, for example, mutiny, all those grievous offenses in, I think, your section 553 of the code, those are serious offenses where the accused person would not be allowed to say, I don't want to be tried by a jury, I want to be tried by a judge alone. However, when the accused person still says that I don't wish to be tried by a jury, what would then happen is that he would need to seek the consent of the Attorney General because of the gravity of that offense. All of this is to ensure that the accused person gets a fair trial, which he has a right to under your Canadian Charter on Right of Freedom, right? So the moment he elects or he insists that he doesn't want to be tried by a jury, then he needs to get an exception from the AG. So when you're dealing with an indictment, these are some of the issues that you have to have at the back of your mind. One last very important one is when it comes to preliminary inquiries. We'll delve into it in the intensive class as well. But because I'm highlighting the key things to consider when you're thinking about indictable offenses and summary offenses, I want to mention this one. For your indictable offenses, because your indictable offenses are deemed to be those serious offenses, right? You need to have what they call a preliminary inquiry, which is not as of right, by the way, because either the prosecutor or the defense would have to apply for that to happen, to say, I want to have a preliminary inquiry. So what is a preliminary inquiry? Your preliminary inquiry is the procedure where the court decides whether a prima facie case has been established against an accused person. Does this make sense? So before you go to file your indictment before the Superior Court of Justice, right, a lower court would have had an opportunity to review the facts of that case, to see or to come to the determination that there is a prima facie case. What does it mean, a prima facie case? What does that mean to us? On the face value, that's what it means. On the face value, without going deep into the case, is there anything, is there any evidence before this court on the face value that suggests that the accused person has committed that crime? It need not be something very, detailed. It may just be something as simple as, was the accused arrested at the scene of the crime? It may be as simple as that. Is there anything connecting the accused to the crime on the surface level? So the provincial court would have to reach that determination first before that case then goes to the Superior Court of Justice. What is the whole essence of that? Can somebody tell me? Why do I need to go to a preliminary inquiry judge to get a determination that there is a prima facie case before I then file my indictment before a Superior Court of Justice? What is the rationale behind that? Why should I do that? Anybody want to say something about that? Anybody?
I think it's possible for an accused person to be discharged after the preliminary inquiry if there is no prima facie case. So he could be discharged and then maybe with the possibility of being charged later on if fresh evidence were to surface, so that you don't waste the time and then put the accused through the serious criminal procedure if there was no basis that he committed the offense, something like that.
It's not something like that. That's exactly what it is. Thank you, Chichi. That's exactly the rationale behind that. Because you don't want to waste the taxpayers' money prosecuting a case that need not be prosecuted. So if you say I've committed the offense of assault, for example, and there is no evidence that I even came in contact with the victim at all. What's the whole point of charging me to court and then going all the way to waste taxpayers' money? So that's the whole essence of it, actually, is to save time, and also having at the back of your mind that the accused is presumed innocent, so you don't want to put him through the ordeal of trial only for the Superior Court to say there was no case, right? So when you're dealing with an indictable offense, you may have to deal with the preliminary inquiry. If you're dealing with the preliminary inquiry, the preliminary inquiry judge's job is basically to reach a conclusion that there is a prima facie evidence or there is no prima facie evidence. If there is no prima facie evidence, it means the case cannot proceed. It means the accused can be discharged with the possibility of the prosecutor bringing back the case when new evidence surfaces, just like Chichi said, right? So that's the whole essence of your preliminary inquiry. So you see, when you're dealing with classification of offenses, there are a couple of things, like you've seen, that you need to pay attention to. And for the purpose of NCA exams, you need to be able to avert your mind to these things so that you are able to put down the appropriate responses in your exam. So it has two implications: penalty and what? Procedure. Classify your offenses that way, then you are able to say, okay, if it's an indictable offense, I'll go by way of filing an indictment. If it is a summary conviction offense, I go by way of filing an information, right? When you're dealing with preliminary inquiry as well, what you're filing is an information. It is when the judge now says there is a prima facie evidence and you are now able to proceed to Superior Court, that information you have filed changes into an indictment. So when you move from the provincial court to the Superior Court, the information you filed in the provincial court for your preliminary inquiry proceeding then turns into an indictment when you proceed to the Superior Court of Justice. Does this make sense? So it is very important to understand this difference just so that you're able to apply the appropriate penalty and then procedure. I also mentioned that it also touches a bit on your sentencing. If you're dealing with your summary conviction offenses, for example, you know that your summary conviction offenses, the punishments are less than, the punishment is less than 2 months. When you're dealing with sentencing, it then means that all of those sentencing options that you have, you're able to limit it immediately, because it means that probation, community service, and all of those other options becomes readily available when you're saying it is a summary conviction offense. So when you're dealing with your types of offenses, I always say you have 3 things at the back of your mind. You want to know the penalty, you want to know the procedure, and then the penalty also helps you to now determine what sort of sentencing that should be, pronounced. Because when you deal with your indictment, the penalty is above 2 years. It automatically means that you cannot be having community service probation under all of those. It means that you'll be dealing with imprisonment and all of that, right? So it helps you to sort of strategize and know what is applicable and what not. So that is the importance of your classification of your offenses. We'll zoom in on that in the intensive class as well. Another thing is the limitation period. I don't know if I mentioned that. Your summary conviction offenses have the limitation period of 6 months. So if I've committed an offense that is considered a summary conviction offense, you must prosecute me within 6 months. Otherwise, it becomes statute bad. Or if I've committed an indictable offense, that one, there is no limit. Anytime you are ready to prosecute me, you're free to do that. So you see, so it helps you to all understand all of these things. Now, interpreting your criminal law provisions, that's the next topic in your syllabus. How do you interpret your criminal law provisions? So in the past, they say to you, you apply what they call strict construction. What is your strict construction? Your strict construction is basically saying the criminal law provisions will be interpreted, and when you come across any ambiguity whatsoever, that ambiguity will be resolved in favor of the accused person. Because again, your presumption of innocence, right? Your principles of fair hearing, all of that come to play. Because if the moment you have any ambiguity in your law, the accused person has to take benefit of that ambiguity. Because the danger is we don't want to convict somebody that ought not to be convicted. There's that thing we say about you should 300 men than punish one man, you know? So you don't want to send the wrong person to jail. The moment you have any ambiguity in your law, you apply your principle of strictness construction, and then the accused person will take the benefit of that. But going forward, Parliament have come to say that perhaps this strict construction should not be the case, right? What should be the case? They come and tell you about the purposive interpretation. What is a purposive interpretation telling you? From the word purposive, what it's basically saying is that it takes the strict construction understanding, saying, yes, consider the ambiguity. If there's ambiguity, you resolve in favor of the accused person. But before you get to that, why not look at the intention of the Parliament? Why not interpret the entire, law? How do you interpret what are the things you consider in interpreting? For example, in your criminal code, your section 2 is very important. It is the part that gives you all the definition in your criminal code, all the words that ought to have a definition. You find it in your section 2. Don't joke with it, right? Section 2 is there for you. And then your criminal code is also divided into various parts. In your various parts, the beginning of the parts, you have some words that are also being interpreted, that is interpreting the words in that particular part. So first you have your section 2 that deals with the entire criminal code. Then you have the words in the beginning of each part that explains that part. And then sometimes you have your words in and around the provision itself you are reviewing. So those are the techniques that help you to interpret the criminal code. So what the purposive interpretation is telling you is that you need to now understand the rationale behind the particular enactment. You need to understand the intention of the Parliament. What exactly is the rule, the purpose of enacting that law? So when you have that understanding in mind, then you use that to interpret that section you're dealing with. So instead of jumping straight to the fact to say, oh, the accused person will take the benefit of any ambiguity, why not consider the intention of the Parliament first? Consider what they are trying to achieve first. Then when you consider all of that and you still don't have clarity as to what the law is seeking to do, then the accused then takes the benefit of the ambiguity. Does that make sense? So your principle of interpretation helps you to get to the point to say the accused should be charged or should not be charged, or should be convicted or should not be convicted. The moment you have any ambiguity, then of course the accused will take the benefit after considering the intention of the Parliament, of course. So that's where your purposive interpretation comes into play, right? So, and the case they gave you here is the case of Aram Pare. Aram Pare is the case of the guy who murdered somebody 2 minutes after assault. But the section he was being charged says that anybody who murders somebody while committing an assault should be charged for a first-degree murder. Do you see? But this guy committed this offense 2 minutes, sorry, the murder or the death occurred 2 minutes after the assault. So when you apply your strict construction, what would that mean to you? Topper Lucas. The case of Aram Pare, don't worry, the answer may not be right. I just want to know you're following me. The case of Aram Pare, right, is a case of the guy who assaulted somebody that now led to death 2 minutes after the assault. Now, when you go into your criminal code, you find that when you commit an assault and somebody dies in the process, that is first-degree murder. So the issue is, should he be charged for first-degree murder? When you apply your strict construction and then when you apply your purposive interpretation, what will be your conclusion applying both principles?
You might say that I didn't kill him.
Yeah. Applying what principle of interpretation?
Purposive.
If you apply your strict construction, you'll be saying you didn't kill him, right?
Yes.
But going by the intention of the act, what do you think Parliament is trying to achieve?
I would say that what they're trying to achieve is to make sure that you are your action caused the death of the person, so therefore you are responsible for the death of the person.
Good. Good. What Parliament is trying to achieve basically is that you do not assault someone to the point that it's so grievous that they even die from it. So if you assault someone and they die from it, then it is your act and you should be punished for that. So, but if you go by way of your strict construction, you will be telling the examiner to say, oh no, the death occurred just simply 2 minutes after the assault. It was not while committing the assault, and as such, it should not be convicted, right? But now, your purposive interpretation is saying no. What is the intention the Parliament is trying to achieve? What is the mischief they are trying to correct? And then if you apply that, you will get to the conclusion to say that he should be convicted for that, because 2 minutes after, come on, is as good as you killed him, right? So that's the whole essence of that. So for the purpose of the exam, I always say this to my students, that when you read any part of your syllabus or any part of your test material, ask yourself, in what manner would question is a question likely to come out of this? I'll give you an example. For chapter 4, in my exam, I was given section 267 of the code, which talks about assault causing bodily harm or using a weapon. And in that section, there was no way I could have done justice to that question if I didn't go to my section 2 of the criminal code. It was impossible. So the whole essence of this chapter is for you to know that when you've been asked to review a particular section and you find some sort of words that you think it is vague, that you think there should be more to this word, and you don't find that word in your section of your code, know that you should go to your section 2. Know that you should check the beginning of the part of the criminal code. Know that you should check around the section for possible definition of those words. If you don't do that, you'll be running foul. So that is the takeaway from this. And of course, knowing that you need to apply your purposive interpretation. That is the situation as it goes henceforth. Now you have your French and English language also in your syllabus, and we know that Canada is bilingual. You have your French and then you have your English, living together in Canada. What that means is that you necessarily need to have 2 types of enactment, the one written in English and the one written in French. Now, these 2 types of law can help in interpreting, right? So when you find sometimes some words are vague in the English version of the criminal code, the French version of the criminal code may be able to shed light on some of those words. So that's, for NCA purpose, I've not seen this much, like you don't need to worry much about that, right? But it is there for you to know that your French and the English version of the criminal code also help in interpreting and bringing about the intention of the Parliament, right? So that's for that. And then, of course, your charter. Your charter is there as well. Your charter had always been, is a very important part of your criminal law that you can't miss. So it also helps in interpreting. So any law that will be interpreted in such a way that contravenes the charter will be held to be unconstitutional. So that's the whole essence of the charter there. So this part, it's safe to say I've completed the first part of the syllabus. I call it the introductory part. It gives you the foundation to everything, right? But you may not find questions specifically on these parts. So the part I consider very important, I'm not saying that first part isn't, right? But the part I consider very important is the elements of criminal offense. That is where it gets tricky for criminal law. That is where people sort of have so many questions, and we'll try to see what we can do to cover as much as possible in this part. So now, elements of criminal offense, what does that mean? Chichi, you have a question?
Yes,
please go ahead.
To ask you, but it's been coming up in my mind and I needed to get your view on this. You just mentioned something about an exam question you had, and you had to refer to section 2 of the code in order to, answer the question. So it comes to also for me to ask, how do people, when they use the criminal code in the exam, how to actually, if it's a section you've not looked up in the criminal code before, how to save the time, because looking at section 2 now is at least 4 pages of the syllabus. So let's say you see a word or a phrase in the question and you're not familiar with it, if that you don't even know whether it is in the definition section.
Yeah.
Then how safe is it to actually start reading the definition section at that point? So that's one, because of what you just mentioned. Then another is the fact that one big thing we're expected to do for the exam is to actually identify the elements of the offense. So if it's an offense that you have not read before, how do you start to read it in the exam in order to actually identify the Actus Reus, the main elements, more to say? I don't know if
I get
you have an idea. Yes.
I get you, Chichi, and you're asking the right questions. Actually, this is what the introductory class this is what you should get away from the introductory class. This is the whole purpose, to provoke your thoughts, right? So for the first question as to how to know what to look out for when you have to resort to definition, the particular section I was asked to review in my exam is section 267, and it touched on weapon. So there are some words, and I don't know, this is where your lawyer skill would just come to play, because you know that for certain, using a weapon, there must be some, I don't know, some things that are considered a weapon, right? So for the purpose of criminal law. So when you have, the way I looked at it in my mind, and how I always tell my candidates is that when you read any section, to start with, we're going to be reviewing some of these sections in the class, so you're going to get used to the words. When you're asked to review any section, I find there is a word that is vague, that is just not, detailed enough, that looks like there should be more to it. You just flip through your section 2. Now your section 2 has been arranged alphabetically. So once you identify and you underline that word, for example, in my situation was a weapon, I just simply go to W, right? And then I look through the weapon section. And then it tells you what amounts to a weapon, what does not amount to a weapon, right? So you would see, you will see from the way the section had been enacted that it's pointing you to a particular part of criminal code. So apart from the definition section, there are also some sort of offenses in your criminal code that when you've been asked to review it, you must necessarily have to review some other sections first. Now, this may sound a bit tricky, but what I've done for my students is that I've identified at least 2 of these kinds of offenses in the criminal code that you need to mention other parts of the criminal code first. Now, in your criminal code, for those who do have it, there is a cross-reference part underneath your criminal code that takes you back to some other offenses. So there is a cross-reference part under your criminal code. That's the particular section you've been asked to review that will refer you back to other sections. When you see those cross-references, then you would need to check. And I'll give you a quick example. Your offense of assault, for example, right? You have different types of assaults in your criminal code. And the basis for all of these different types of assaults is your section 265. What is your section 265? It is the section that actually defines assault. So there is no how. So if you've been asked to review, for example, section 267 in your exam, which is telling you assault causing bodily harm or assault using a weapon, then you're asking yourself, what is an assault? So that's the kind of example I'm telling you. So there are some words like that is just looking in your face, telling you there is something else you should be looking at. So because if you've not looked at section 265, you don't know about section 265, and you're coming across a section that is telling you, analyze whether the accused can be convicted under section 267, that is telling you anybody who commits an assault using a weapon. Anybody who commits an assault using a weapon, then you're asking yourself, what is an assault? Some criminal code would give you cross-reference that points you back to section 265. Some would not. For example, I don't have that criminal code, right? But assault is in your face. Because the only question you're asking yourself is, oh, what is an assault? Anybody who commits an assault using a weapon, what is an assault? I don't know what an assault is. Then it's telling you there's another part of your section that you need to be looking at. But you need not worry, because my understanding of this course, you only have 2 types of offenses like that. And I've mentioned assault, and the other one would be negligence, criminal negligence. We'll look into that in class. So you're not going to have so much issue worrying about, oh, what if I get an offense section that I don't know whether to review another section for? You won't get to that point. You'll be fine. But for the purpose of answering Chichi's question, when you do have a section that you've been asked to review, and you find any word vague, always underline your words. In class, we always have that exercise where we underline every key part of the section that we review. So you actually get familiar with everything, right? So when you have all of those words that are just vague and you're asking yourself, what is this? There should be a definition of something like that. 3 parts of your criminal code will help you. Your section 2 will help you. The beginning part of that section you are reviewing will help you. The section itself will help you. For example, if you look through your section 265, it explains to you what your assault is. We don't have time to do that today. It explains to you what an assault is, and it tells you what amounts to an assault and how the accused person will be held to be convicted for an assault. So when you get any other variant of assault, for example, you have your sexual assault, you have your aggravated assault, you have your assault causing bodily harm, or assault using a weapon. These are different types of assault. It is impossible for you to review any of these types of assault without touching on section 265. The same thing for criminal negligence under your section 219, 219 of the criminal code. There is no way you get a question on criminal negligence, maybe criminal negligence causing death under 220 and 221, that you will not be talking about 219 first. It is impossible. So those 2 offenses, there is no way you will not touch on other sections before you actually analyze the section you've been asked to review. That is to answer your first question. Chichi, do you feel comfortable with that answer for your first question?
Yes, thanks.
Yeah. Now for your second question, what to look out for, what to do, how to identify the elements of the criminal offense. That is the knowledge NCA expects you to get when you talk about the offense part of your syllabus. And that is what we will be achieving. We'll try to achieve that today if possible, but that is the fulcrum of part 1 of my class. Offenses, how to identify criminal offenses, how to understand your Actus Reus and mens rea and all of that. So we'll go into that quickly right now. So your criminal law offenses, like we already mentioned, there are 2 types of offenses, right? Can somebody quickly give me the 2 types of offenses? I just want to know we are following. Anybody quickly? The 2 types of offenses we have.
Criminal and regulatory.
Good. So criminal regulatory offenses, they have different elements. So when you talk about criminal law offenses, different elements will apply. When you talk about your regulatory offenses, different elements will apply. So now let's talk about elements of a criminal law offense. What are the elements of a criminal law offense? We all did criminal law we are from different jurisdictions, but we must have done criminal law. It is the same thing. Your element of criminal offense is the Actus Reus, which is the acts, prohibited acts, your mens rea, which is the intention, the mental element. Now, for a criminal law offense to be said to have been committed, these 2 elements must be present, and they must be present at the same time, right? So you must have the Actus Reus, must have committed the prohibited acts, and then you must have intended to commit the prohibited act, which is the mental element. Those are the 2 things you need to have in mind before you can say a criminal law offense had been committed, right? So what is Actus Reus? Where it gets a bit very interesting for the Canadian law is that they pay more attention to the constituents of these elements. So what amounts to an Actus Reus? What are the things to look out for when you talk about Actus Reus? A couple of things. I'll run through them briefly. The act that had been committed must actually be prohibited by law. That is one. Whatever the accused person had done, it must have been that thing that the law says it shouldn't do. Actus Reus. The act itself must be prohibited by law. 2, the act must be willful. It must be voluntary. You must have committed this act voluntarily. Now, don't confuse this with mental element. This is where it gets a bit tricky, because somebody says to me, if the act's supposed to be willful, if it's supposed to be voluntary, then you're essentially telling me about the mental element. No, not necessarily. I know it gets to a point where distinguishing your actus reus from mens rea becomes blurry, where you are not actually supposed to say, oh, this is the actus reus, this is the mens rea. What the NCA expects, what the criminal law jurisprudence expects is for the lawyer to know what amounts to actus reus and what amounts to mens rea. Sometimes you are not able to separate them, but the times you are able to separate them, you must know that the act being voluntary or being willful is different from the mental element. And I'll explain. So for your actus reus to be complete, I've said that the act must be willful, must be voluntary. What does this mean? It means that whatever it is I have done, it is my act, and it is what I want the act to do. And I always give this example of somebody suffering from seizure. If Hidayat is suffering from seizure, she's not able to control some part of her body because of some illness she's suffering from. And Chichi walks before her. And for some reason, I'm not able to control my hands, and I slap Chichi. Is that my act? Is that act voluntary? Why? It is not voluntary because I just was not able to control my hand. Right? So when you go to court and you charge me to say I've slapped Chichi, I'll simply tell the court, my lord, my hand just kept moving this way and I couldn't stop it. It is different from intention. It's similar, but it is not so. Because here you are focusing on the act, not the mind. What did Hidayat do? Okay, she slapped Chichi. How did she slap Chichi? She slapped Chichi because her hand just kept moving this way. She couldn't stop her hand. It has nothing to do with intention. It is similar, but it is not so. So for your actus reus elements, number 1, that act I have done must be prohibited by law. 2, it must be voluntary. And 3, what's the third one? It must be, let me flip through my, yeah. The third one is that Chichi must not have consented to me slapping her. If Chichi consented to the slap, she enjoys being slapped. I know you don't, Chichi, you don't look like it. Yeah, and she just consented and said, Dad, slap me. And then I slapped her, and then she went to court saying, if Dad slapped me, she should go to jail. I'll simply say, you said I should slap you, you consented to it, right? So part of the element of actus reus is that the victim must not have consented to the act, and the prosecutor must prove that. I didn't tell you guys what the standard of proof is for the prosecutor. I'm sure we all know. It is beyond reasonable doubt. The prosecutor has the burden to prove that I've committed the offense beyond reasonable doubt. What is beyond reasonable doubt? It need not be beyond all shadow of doubt. It must be, you must have proven it to the extent that the jury reasonably agree with you that that offense has been committed. That is beyond reasonable doubt. I don't have a doubt that Dad slapped Chichi, then she goes to jail, right? That is beyond reasonable doubt. So I've mentioned 3 things for your actus reus, right? The 4th one is not always necessary, and that is causation. Don't forget that your element of criminal offense is divided into 2. And the part I'm talking about right now is your actus reus, right? That is the prohibited act itself. The 4th element of your actus reus is that the prosecutor would have to prove causation. What is causation? If the section you've been charged under expects that certain circumstance or certain consequence must arise as a result of the prohibited conduct, then the prosecutor must prove beyond reasonable doubt that my act led to that consequence. For example, if the law says that I must not assault anybody, and that if I assault somebody and it leads to injury, then I have committed the prohibited act. The prosecutor would have to prove beyond reasonable doubt that my assault actually led to that injury. If prosecutor is not able to link that my act to the consequence, then the element of the Actus Reus is not complete. And there are two different types of causation. We'll talk about them, we'll zoom in on them. The two types of causation are the factual causation and the legal causation. The factual causation is, as the name implies, is focusing on the facts. The consequence come about by my conduct, in fact. And in law, the consequence come about by my action in law. So basically you're saying the factual causation is I slapped Chichi and it led to injury. You guys don't think I'm violent. I'm not a violent person, right? And it led to injury. So prosecutor would have to prove beyond reasonable doubt that it was my act that led to that injury. That is factual causation. When you're not talking about the legal causation, prosecutor would have to show that that consequence was prohibited in law. That the law has stipulated that if I slap Chichi and it leads to injury, then I have caused that injury in law. Does the difference make sense to us? Factual and legal. Both has to be, present at the same time before you can say that causation had arisen. Now, it is not in all instances when you talk about Actus Reus that you have to talk about causation. It is not in all instances. How do you know whether to talk about causation, whether not to talk about causation? You find out in the intensive class, right? Because when you look at your section, there are some words that will lead you to know that you need to talk about causation. The first of those is cause. Anybody who did XYZ, causing XYZ, you must show that that consequence occurred. Then you come talk about causation. But when you don't have that in there, you do not need to talk about causation. I remember having this conversation with some of my colleagues when we did the exams, right? So you need to know that. You need to be able to differentiate that. Is this clear so far? So this is Actus Reus in a nutshell. Do we have any question on it? Do you want to contribute? Do you want to clarify? Do you have any question? I want to hear. Kemi, go ahead. Don't think too much, just talk.
Okay, it might take you back a bit, but
okay.
When you started, you said that Actus Reus and mens rea are elements of criminal offenses.
Yeah.
I want you to please clarify for me. Does that mean that for regulatory offenses, these two elements don't have to be present?
Yeah, I think you're going far ahead of the class, okay. But I like the way your mind is working. Yeah, it is different. And we'll talk about that if we get a chance to talk about that, right? So, but it's different. So that's Actus Reus. If we don't have any question, I can move to mens rea. Mens rea gets a bit more complex, right? But do we have any question? Chichi, how are you? Dara, Cherry, are you guys with us?
I'm good.
Yeah, you're good, Chichi.
Yes,
Dara, good. What about Cherry? Do you have any questions so far? I don't think Cherry is there, which is why I like the video to be turned on, right? Anyway, so we can go ahead and talk about mens rea.
I don't have any questions.
Okay, but are you following those, Cherry? Is there a reason you don't want to put on your video?
Actually, it's night in India, so everybody's sleeping at home.
Oh,
so
okay.
I switched off my video. Yeah.
Okay, it's okay. But are you enjoying the class so far? Does it make sense to you?
Yeah, it's making sense to me, and I'm looking forward for the regular classes also for my January exam. So that would help me more, I guess.
Yeah, it will help you more. I look forward to having you, Cherry. So yeah, let's go ahead and talk about the mens rea now. Remember, for your elements of criminal law offenses, these two must be present at the same time. You take away the Actus Reus, which I believe we all have, understanding on, even though not in depth, but at least you have a good idea of it. For your mens rea, you want to talk about the mental element. Now, in the jurisdiction I came from, we didn't bother, subcategorizing the mental element, right? Which I found very interesting when I landed in Canada. They paid a bit more attention to what constitutes mental element, which I think I love a lot because I worked as a prosecutor briefly before I left Nigeria. So I really appreciate this part of the course. When you talk about mental element, you're looking into the mind of the accused person. You want to know if the accused person intended to commit the offense. And then it takes you back to your presumption of innocence. And then it takes you back to your principle of fundamental justice, because you don't want to convict somebody that didn't have the intention to commit the offense. You'll be doing great injustice. So the law had paid a whole lot of attention to this part of the course because they want to avoid convicting the wrong person, right? So when you talk about mental element, it's been subcategorized into two. The first one is your subjective mens rea. The other one is your objective mens rea. Now, what is your subjective mens rea? So subjective mens rea is telling you that before you convict me for an offense, you look into my mind, my own very mind. Did Hidayat intend to commit that offense? Now, can you actually tell my mind? Can anybody actually tell anybody's mind? It's impossible to tell anybody's mind, right? How do you tell my mind that I intend to do something? There's that principle of law that explains it to you. It says to you that a man intends the natural consequence of his action. If I did XYZ that led to XYZ, then I intended to do that thing, unless I bring a defense of mistake of fact. But outside that defense, because I did the act, then there is the presumption that I intended to do the act, unless I prove them wrong. Does this make sense? So you can't tell my mind, right? But you can also tell my mind by looking at the circumstances of my action, by looking at the events. You'll be able to come to a conclusion that based on the event that had occurred, Hidayat must have intended to commit that offense, unless I bring a defense of mistake of fact. So now, subjective mens rea is looking into my mind to see if I intended to commit that offense. Now, this is the topmost intention that you can have, because it means that if the courts look into my mind and they don't find that I committed that offense, I will be acquitted, right? So that is the subjective mens rea. And the law expects or presumes that everybody will be tried based on their subjective intention. In fact, for a very long time, the criminal law jurisprudence had not been open to objective mens rea because it is very risky. It is possible to convict the wrong person when you use the subjective mens rea, the objective mens rea. I'll tell you quickly what objective mens rea is. Like I said, subjective mens rea is looking into my mind, but the objective mens rea is looking into a reasonable man's mind. Subjective mens rea is applying the reasonable man's standard, reasonable man's test. Instead of asking the question, did Hidayat actually committed this offense? You are asking, would a reasonable person in Hidayat's circumstance commit this offense? That is your objective mens rea. So when you answer the question in the affirmative to say a reasonable person in Hidayat's circumstance would not commit this offense, then I'm convicted for that offense. right? So the subjective mens rea looks through the mind of the accused person. The objective mens rea applies the reasonable man's test. Now, depending on the gravity of the offense, we begin to ask what offenses will require a subjective mens rea, what offenses will require an objective mens rea. We will zoom in on that in class. It's impossible to achieve it in this class. As a matter of fact, my time is up. But I would conclude on this mental element because I know it's the tricky part of the entire syllabus. And you would always get the offense section question that will probably get 40 marks, give you 40 marks, marks on it. So for the subjective mens rea, I'm going to zoom in on that quickly. I've told us that it looks into my mind. It's not concerned about a reasonable man or anybody. It's just idiots. And offenses that will require the subjective mens rea are most often the grievous offenses, your murder, your treason, your mutiny, those offenses that are considered very grievous with high penalties would require a subjective mens rea, right? How do you then know that a section of your criminal law or your criminal code require a subjective mens rea? That's where the trick comes in. Because your subjective mens rea had now been further subdivided, or no, not divided, have now been classified in different ways as well, right? So under your subjective mens rea, the first kind of subjective mens rea you're looking at is your purposive, or what do they call it? Let me quickly look through how it's actually captured in the test. You're looking at your intention and purpose. That's how it's couched in your syllabus. Intention, purpose, and willfulness. That's your ulterior motive, the major thing that you're thinking about at the time. How do you tell that? So when you've been charged with the criminal law offense, and the law is saying anybody who commits XYZ for the purpose of XYZ can be convicted for that offense. What is the mental element that that section requires? What is the mental element that it requires? You must prove that the required mental element in that section is the actual mental mind that I have. I don't know if that makes sense. I don't know if I use that word in a very confusing way. But before you can convict me, you must show that my intention is the same as what the parliament intended for the accused person under that section to have. That's essentially what I'm saying, yes. So the very first category of your subjective mens rea is the one that talks about your intention, purpose, and willfulness. In the syllabus before now, there is that very great case that I love, Aaron Murray. That case, surprisingly, is no longer in your syllabus. They've replaced it with Aaron Ebert. It can explain it well. But I'm going to explain this point quickly using that Aaron Murray, right? So in Aaron Murray is a lawyer who concealed evidence, and he was now charged for obstruction of justice. Because anybody, of course, who is considered as a clog in the wheel of progress in the wheel of justice can be charged for obstruction of justice, right? So if you conceal evidence that ought to have been useful in court, then you are guilty of obstruction of justice, right? But what was the purpose of Murray's, Murray's intention when he concealed that evidence? Remember, he's a lawyer. His intention at the time was that he concealed that evidence to use it as a strategy in his trial. So he would reveal the evidence, but he intended to use it to cross-examine a witness in the later part of the trial. But when the trial was done, he was charged for obstruction of justice, that he ought not to have concealed the evidence. And now they went into the section that he was being charged under, and the intention that Parliament intended was not Murray's intention. Murray's intention was not to conceal the evidence. It was to use it to defend his client properly in court. So in that light, he was not convicted, he was acquitted, because the whole thing was that the intention the Parliament intended for that offense was not his intention, right? So the applied the subjective mens rea, looked into his mind to see what his intention was, and then they held that he didn't have the intention to commit the offense of obstruction of justice, right? Why that case was taken away from the syllabus, I don't know. But they gave you the case of Aaron Ebert, yeah. And I think the case was, the case of Aaron Ebert was the case of a guy who basically, I don't know, I don't want to go into cases today, but this guy was charged with murder alongside the accused person. He had aided somebody in committing murder, and he was charged for being a party to the murder. And the issue was whether he should be convicted, whether he had the subjective intention, the subjective mens rea to commit the offense. He went to court to say, oh, I was under duress, blah, blah, blah. Therefore, I didn't have the intention. The court said, no, that your intention to commit the offense is one thing, your defense is another thing. So if you say, the issue is, did you commit the offense? Did you assist somebody in committing this offense under section 21 and A and B, right? The answer is yes, you did the act, right? Because his own role was to call the victim down, and then the accused, the main accused, the principal offender, shot the guy, right? So did you do the act? Yes, you did. Did you intend to? Yes, you did. You intended to do it. But then you have a defense, which is okay. You were threatened. But that intention that Parliament intended under that section, you add it. So the court applied subjective mens rea and said he had it. The defense may avail him, but that's another thing entirely, right? So that's the case of Aaron Ebert. Then the second type of subjective mens rea in your syllabus, they call it subjective mens rea with objective features. Subjective mens rea with objective features. I always find this very interesting because in one breath, they are saying, look into the mind of the accused, subjective mens rea. In another breath, they are saying, also then apply the objective feature. Look into the reasonable man's test as well. So you have this in one type of mens rea, two things, subjective, objective, in a particular subjective mens rea. And like I always like to paint the picture of clarity, you need to understand why this is so for you to really grasp the concept the Parliament is trying to push through here. So when you find in your exam two types of offenses, I want you to note this very clearly. The offense of fraud or anything that touches on fraud, fraudulent conduct, one. Sexual offenses, two. Those two types of offenses, the moment you have any question in your exam that touches on any of these offenses, you should know that the required mental element for you is the subjective mens rea with objective features, and I'll explain why. Your subjective mens rea with objective features is basically saying that you look into the mind of the accused person, and then you then apply the objective standard as well. It is applicable in two types of offenses, and those two types of offenses are such that the society or the Parliament had pinned down a standard to them. When I confuse you, please let me know. But I'm trying to explain this as clearly as I can. For your offenses of fraud, for fraud, you have to check the mind of the accused to see if he intended to commit the fraud. That's where your subjective mens rea comes in first. Did you intend to defraud me of my hard-earned money of $1? If that intention was found to be right, then whatever explanation I have as a result of that fraud becomes very irrelevant. So for example, I am a good person. I want to help the public. I want to help the people. Then I look at Kemi and say, Kemi looks like she's very rich with this a nice jacket. I'm going to sneak into her account and defraud her. Then I'm going to use the money to do good to the society. So that looks like she needs a lot of money. She's so poor. Somebody is going to defraud Kemi to favor me. You see, this accused person has a good intention, right? So in his mind, what he's doing would not be fraud because he's helping the society, he's helping it, right? But the law is saying to you that the moment you are dealing with fraud, there must be a standard definition to fraud, such that your explanation as to why you commit fraud becomes very irrelevant. So the moment I defraud Kemi, the court is asking, did I intend to defraud Kemi? The moment they answer that question in the causative and in the affirmative, whatever explanation I have to say why I defrauded Kemi is not relevant. So in that instance, the court is now applying the objective standard. As to the society's perception of fraud remains what it is. What individuals consider as fraud is not relevant. Does this make sense? So if I defraud anybody and I say I've defrauded that person because I want to be able to help society, the court will tell me to keep quiet. The only thing I want to hear from you, did you intend to defraud that person? If the answer is yes, then your reason becomes irrelevant. In that instance, the court is applying objective standard to it. That is where your objective features come into play. Does this make sense? And that's for fraud. And one of the cases they gave you under that for fraud, I think, is the case of Actus Reus. I can't go into that case right now. I don't have time for it. The other type of offense is your sexual offense, right? So for your sexual assaults, your sexual offenses, the court will apply subjective mens rea with objective features. Why? Because the court first want to know, did you intend to touch the person in a sexual way? If the answer is yes, then whatever your understanding of sexual activity is does not matter. So if I as the accused person met with a victim and I touched them in their private areas, but my understanding of that touching is not sexual, that my understanding is not relevant to the court because there is a societal standard to sexual activity. We all know that anybody who goes touching people's private is assaulting them sexually. So if you go to say, oh, I don't think me touching her the way I touched her was sexual, the court will tell me to keep quiet. All I want to know is, did you touch the person? Did you intend to touch the person? Did they consent to the touching? Did they not consent to the touching? Again, the issue of consent is another conversation we're going to have in the intensive class because there are several, aspects to it, right? But I'm going to leave that. So the issue of consent, did you touch me? Did you intend to touch me? The moment the court says yes to that, then I'll be convicted. My explanation as to my understanding of sexual activity becomes irrelevant. So subjective mens rea with objective features. You would only be using this in two instances, fraud and sexual offenses. When you go into your example and you see any of these offenses, you know that you are coming to this part. So it's easier to note because you're only dealing with it with two kinds of offenses. Does this make sense to us? So that is subjective mens rea with objective feature. Any questions so far? Any question? We are actually out of time. So then there's the next type of subjective mens rea is knowledge. Back then when I was prosecuting and you want to deal with mens rea, you are asking questions like, how do I actually prove to court that this guy actually committed the offense and he intended to do it? Back then, my law didn't tell me, look at knowledge, look at this. It is when I came here, I really appreciated it because on my own, I had to figure that out, like, what do I need to do to show to the court that this person intended to do this thing? Canadian law is telling you, look at knowledge. Did this person have the knowledge of the particular fact? A good example is you slapped a police officer. The question subjective mens rea is asking you is, do you know the person is a police officer? The moment you know that the person is a police officer, then you intended to slap a police officer. Makes sense, right? I mean, that's fantastic. So the moment you have knowledge of the existence of a particular act, and you act based on that knowledge, then you are deemed to have intended to commit that offense. So you look at knowledge. It helps you to say somebody has committed the offense and they intended to commit the offense. That's the third one. The fourth one is willful blindness. This is very related to knowledge, because when you are willfully blind, like the name implies, like you should have known the existence of an act, but you chose not to know just because you want to be able to deny culpability. So that willful blindness will be used as an element of your subjective mens rea, because you could have known, but you chose not to know. You're being willfully blind. For example, if you assault a minor and you had the opportunity to simply ask the minor, how old are you? The person looks visibly to you like a minor, but you don't want to know the person is a minor because you don't want to be charged for assaulting a minor. The law will tell you you are guilty because you could have known. The facts are there for you. You only need to take a step further to find out, but you deliberately chose not to find out simply because you want to be able to tell the court that you did not know. Willful blindness will come to you and say, no, keep quiet. You've been willfully blind here. Therefore, you are guilty. That's another type of subjective mens rea. Does this make sense? The next one is recklessness. Recklessness comes into play. Now, before I talk about recklessness, I always tell my students, and they always ask me, how do I know when I review the section in the criminal code that I'm supposed to talk about? I'm supposed to talk about knowledge, I'm supposed to talk about the first one I mentioned, and I'm supposed to talk about willful blindness. How do I know these things? I said to them, there are some words in your criminal code that point you to these things, right? When you require a subjective mens rea, first of all, there's a presumption that the criminal law jurisprudence expects that the applicable mental element is subjective mens rea. There's that presumption, right? Then you then look out for some words like intent. In my class, we always do that exercise where we review the section and begin to underline the relevant words. Intent is one word. No is another word. Mean, M-E-A-N, is another word. Which other one? Essentially, those three words. The moment you see that word, anybody who intends to do X, Y, Z, they are talking to you about subjective mens rea, and you will have to apply subjective mens rea. Anybody who means to do X, Y, Z, they are telling you about subjective mens rea, you will need to apply subjective mens rea. Anybody who knows, they're telling you about subjective mens rea, and you must apply, right? Then sometimes these words are absent and the law still requires you to apply subjective mens rea. What do? This is where your recklessness comes in. When you look at all those sections and you do not find any of these words, I tell my students, go to the facts of your case. Check to see if the accused person had been negligent in one way or the other. If he's been negligent in one way or the other, then you apply recklessness. What is recklessness? Your accused person is being reckless when he sees that his action will lead to a prohibited circumstance or consequence, and he chose to do that act anyways. He saw the risk and he took the risk. He knew the consequences of his action. He took it anyways. He was being reckless. Your recklessness is a subjective mens rea. You apply your subjective mens rea. Does this make sense to us? So this is me just talking to you about subjective mens rea. There is also the objective mens rea that I don't think we can talk about today, unfortunately, because I'm 19 minutes past my time already, right? So, but I love criminal law. It's very interesting. I know that when you grasp the concept, you'll be amazed as to what the law seeks to achieve with criminal law. It's all about justice, all about justice. You don't convict me unless I actually intend to do that act. How do you tell that I actually intend to commit that act? Those are the 5 things we've just talked about right now, right? And then your objective mens rea is talking about the reasonable man's test. We'll get to that in the intensive class. But what you need to do to study, when you read any chapter, try to ask yourself, which is what I do, what form of question can the NCA come about with this chapter I've read? Narrow it down to something. When you do that, you don't go to the exam and you will never get surprised with any question, right? Does this make sense so far? There are other parts of the course, of course, that we didn't get to talk about at all, right? So I told you that you have 32 chapters in your criminal law, in your syllabus, and we've broken it down into 5. I told you about the offenses, the defenses, the procedure, the police powers, and then sentencing. You see, offenses, defenses, police powers, you can't mix it in exam. Like there's no way you can mix it in exams, right? So we'll zoom in on all of that. I don't know if my introductory class had been helpful to us, but the whole essence is not to teach the course, which is definitely impossible, but it's to provoke our thoughts one way or the other, right? So that when we go into the course and we read, you say to yourself, oh, Idayat said this, oh, Idayat said, oh yeah, I remember she mentioned this, so let me zoom in on it. That's the whole essence of it, right? I want to take your comments, your suggestions, or contribution. Anybody want to say anything before we round up the class? The floor is yours. Nobody?
Yeah, thanks a lot. It has been a very interesting session. And,
yeah.
I think you did great within the time we have. It's really appreciated.
Thank you. Thank you, Chichi. So you have clarity on that, on your criminal law now, right? So that when you read, you begin to internalize more the things we've talked about. That's the whole essence of the introductory class. Kemi, Awobi, say something to us. Say something before we round up the class.
Okay, thanks. Your class was quite informative, so thank you for the time that you've taken. Yes, you're right. The introductory class has given us insight. There are some things that, because I've read the parts that you talked about or what you discussed today, but it gave additional light to some things I just didn't understand, particularly the objective, it was
with objective features. Okay.
Yes, I read it like 3 times because I just didn't understand why you had to be objective and subjective at the same time.
I know, right? Yeah.
It was, yeah. The fraud case, I had to digest it, but thank you. It really helped. Thank you.
You're welcome. I'm glad it helped. Paula, your turn to say something.
Thank you, Heidi. I'm really impressed, let me say that, because you took your time to break down all the concepts and like you just made everything so clear.
I'm happy to hear.
Yeah, everything is really clear.